Welcome to One Happy Lawyer, the estate planning podcast.
Welcome to One Happy Lawyer, the estate planning podcast with Attorney Dan Krause, founder of Krause Estate Planning and Elder Law Center in Wisconsin. Dan has been practicing estate planning and elder law since 1999 and is a board-certified estate planning law specialist. I'm Lisa Millsby, your host, and in this episode, we're talking about planning for minor children. Dan will go over how guardianship works in Wisconsin, what happens if parents don't name anyone ahead of time, and the long-term considerations families often don't think about until they're forced to. Dan, welcome. Thanks for being with me today.
Lisa, it's a pleasure. It's great to see you again.
Dan, what does guardianship actually mean in the context of estate planning for minor children in Wisconsin?
So a guardian is somebody who's going to look out for somebody legally. So we've all heard the term legal guardian, parent or legal guardian. On those forms that we filled out in school, it would say, here's a line for your parent or legal guardian to sign. A legal guardian is somebody who acts as a parent that's not actually your parent. So the only way that you can get a guardianship or guardianship powers in Wisconsin is to go through a court case called a guardianship. Obviously, the court case is actually in the probate court. So it's done in the same court as you deal with people who have died and what's to happen with their assets. But for minor children, guardianships are closed affairs. Now, most court cases are public, but guardianships for minors, they want to preserve the minor's privacy, and so they make those closed. But that's what a guardianship is to appoint somebody in lieu of the parent, and it's usually if the parent has died or if the parent has become incapacitated and unable to deal with the child. But sometimes a child that has been removed from the home because of abuse or other things, sometimes they're also given legal guardians.
Beyond choosing a guardian, what other decisions should parents be thinking about when they are planning for children who are still minors?
So now guardianship for the children works just like when we talked last time about a guardianship for a disabled adult. You know, the court can choose somebody, or the parent, if they pre-planned, they can choose somebody. So if a parent writes in their will, if something happens to me, I want this person to be the guardian of my children, then the court must appoint that person unless there is good cause shown not to appoint them. So almost always the person that the parent wants is appointed. Little story, a very sad story. It is always sad when parents of minor children pass away and create orphans. But there was several years ago, there was a very sad case where the parents of two one-year-old twins passed away in a car accident in Madison nearby. And the two sets of grandparents both wanted to be the guardian for the children. They got along, but they did fight in court over who could be guardian. And both of them said they wished their children would have named the guardian and they would have been happy with that result. But as the children had not decided that, had not written it down in a will, they had to go into court and actually fight over who would be able to take care of the children after the parents had died.
How do financial considerations intersect with guardianship planning, especially when assets are left to children who aren't legally able to manage them yet?
That is a very good question. So with the guardianship, you have guardian of the person and you have guardian of the estate, is what they say. And they are usually the same person, but not always. Sometimes the guardianship of the estate is given to somebody who can manage money better. And sometimes guardian of the person is for the person who may have more time to spend with the child and be able to be more nurturing, let's say. But like I said, the courts almost always appoint the same person to be the guardian of the estate and the guardian of the person. But if you are the guardian of somebody, there is an annual renewal, or not really a renewal. It's kind of an accounting. You have to account to the court where the money of that person is, how much has been used, what it's been used for over the last year, so that it's clear that you haven't been stealing. Guardians do get paid, though, and they get paid out of the money of their wards.
And families sometimes assume that informal arrangements or conversations that they had will be honored if something happens to them. Where do those assumptions tend to fall apart?
Well, it's just not the case. Informal arrangements don't work if other people disagree with them. So let's just say I made an agreement with my friend. I say, you guys have a great family. My kids love your kids. If something happens to me, can you take my kids? And the person might say, yes, I'd be honored to. I think that's a great idea. And they might even ask you the same thing. Well, would you take my kids if something happens to me? And then something happens. Unfortunately, the court doesn't care what that informal agreement was, because nobody really knows that it happened. So if that person comes forward and says, I want to be the guardian, my sister might also come forward and say, I think it's best that I be the guardian. Now there's no preference over either one as far as the court goes. So the court would make a decision, just disregarding any reports of an informal decision, just because they can't prove it.
And how do long-term factors like changes in family dynamics, health, finances, those kinds of things, how does that affect planning decisions for minor children over time?
The health of the children obviously is a factor. If you have a disabled child or a child with special needs, you don't want to name a guardian that's not going to be able to deal with that. Geographic location is also another concern. If you have somebody that you think would be a really great person to be a guardian of your child, however, your child is in school, established there on sports teams, and this person that you would like is way far away, so that your child would have to be uprooted and taken not only away from their family nearby, but all the way to, I don't know, New York, California, somewhere, then you might not want that person to be your guardian. The financial concerns are, is the guardian going to be financially stable? Sometimes a very caring and nurturing person is not good with money. So you might want to have a second thought about whether you want to allow them to deal with your child's money. Now, one thing that we didn't talk about is with a guardianship, as soon as the person reaches the age of 18, the guardianship is no longer necessary. Just like when you reach adulthood, now your parents can't tell you legally anymore where you have to live, what you need to do, etc. Also, the guardian now loses control of your money. So if you haven't made a plan, the guardianship holds all the money for your kids. Maybe hundreds of thousands of dollars are going to be turned over to an 18-year-old that may have a lot of trauma because of the death in the family and all of that, and they might not make very good decisions with that money. So there are a lot of concerns about money with guardianship, especially guardians of minors, because there's no way to save that money for them until they're maybe 25 or 30. Use it to pay for their college if that's what they want to do. If you've made a will or if you've made a trust, you can plan for those things. You can have somebody in your family or your friends hold on to that money until your kid gets more mature.
You mentioned those 1-year-old twins, and it makes me wonder, when's the best time to start this planning process? Maybe even when you're pregnant and you know you're going to be having a baby, because these 1-year-olds found themselves without parents, and maybe they weren't thinking at that time we need to have a plan in place. They were just, getting prepared to have a baby and getting set up to have these children and raise them. When do we need to be thinking about this and making sure that we take care of the kids before something happens?
Well, just like you said, if you're planning to have a child, there's a lot of things that go along with that, getting the crib and the room set up and all that other stuff. part of that checklist should be making sure we have an estate plan that is going to benefit this child. So just another thing to get done, but it's a very important thing that really could affect your children negatively if something is not set up and then something happens to you.
Let's leave our audience with a few specific actions to take. When parents are feeling overwhelmed by these decisions, what do you wish they understood about the purpose of planning ahead, and what next steps should folks take right now if they don't have a plan in place?
So the purpose of planning ahead is just to make sure that your loved ones are not stuck without a plan if something happens to you. Your plan for your life is in your head, typically. And young people especially don't plan for what's going to happen if they pass away or if they become incapacitated. But I hope that some people realize psychologically it really is important to make a plan just in case. So what do you need to know? You need to know that there's experts out there that can make the planning easy. They know the questions to ask. They have all the forms that you can fill out, and you can just make an appointment, typically with an estate planning attorney. An estate planning attorney can help out. Doesn't have to be our firm. We would love it if people would call us. We've got a process that brings them through from the initial meeting all the way to making their decisions and then signing. And it generally takes about 4 weeks to get it all done. I wish people knew how easy it was. It's not free. And for many people, it doesn't seem inexpensive. However, almost all of our clients find that it was well worth it. In fact, we're very proud of all the 5-star reviews we get on Google. And surprisingly, people tend to want to list out the members of our firm that helped them out. They write 1 or 2 long paragraphs about their experiences, and people can go online to estateplanningpeople.com or link to our Google My Business sites. We've got 3 of them because we have 3 locations, and just see how people feel after they've done this planning. Typically, it's a real big weight off their shoulders.
Oftentimes it's rambling around in our head and we don't realize how we can let go of that stress once we take care of it. And I think we'll leave it there today, Dan. Thank you so much for being with me.
Hey, it's a wonderful experience, Lisa. Always great to see you.
You know, folks, this brings us to the end of today's episode of One Happy Lawyer, the estate planning podcast. To learn more about Attorney Dan Krause and his work, again, go to estateplanningpeople.com. Thank you so much for listening. Be sure to subscribe, leave a review, and share this episode with someone who might benefit from it. We'll see you next time.
Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.